Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillahir Rahmanir Rahim. Nahmadu wa nusalli wa nusallimu ala rasulihil kareem amma ba'd. And welcome to another video on the Islamic Knowledge YouTube channel. And in today's video, we're looking at a fantastic book titled Pragmatism in Islamic Law, a social and intellectual history by Fekry Ibrahim. And this book has been printed, I believe, by Syracuse University Press. And as you can see, I have got my notes on this book as well, and you can access these notes by going on to the Islamic Knowledge Telegram channel, and I will upload all the notes there. They are more or less legible, all of them. Now, what's this book actually all about? So this book is actually all about Taqlid, Tatabbu, al-Rukhas, Talfiq, Ijtihad, all of those things which you wouldn't be able to guess just by looking at the title. So he actually has a term that he's created for Tatabbu, al-Rukhas and Talfiq, and that is pragmatic eclecticism. So a bit of a mouthful there, but that is the author's word for Tatabbu, al-Rukhas, Talfiq, and even Takhayyur, all other types of, you could say, different types of words that you can get here. Takhayyur, Tatabbu, al-Rukhas, Talfiq, all of that he puts into the category of pragmatic eclecticism. So this is where basically the authors or the fuqaha in the past are using what you might refer to as something, an idea which is like, what is the best approach? How can we solve this problem? They're trying to be pragmatic, and in doing so, they might be breaking some of the rules that are kind of stipulated by the madhahib. So if you have a just look at the contents page, setting and context, the codification, episteme, and the multiplicity of truth, juristic discourse prior to the 19th century, Tatabbu al-Rukhas in juristic discourse prior to the 19th century, Talfiq in juristic discourse prior to the 19th century, court practice prior to the 19th century, pragmatic eclecticism in court practice. So 1001 cases. So this is quite interesting. The author studies 1001 cases from 3 courts in Cairo and Bulaq when Egypt was under the control of the Ottomans around 17th and 18th century, to show how scholars were utilizing concepts like Tatabbu, al-Rukhas and Talfiq in courts. Really interesting. Again, then he speaks about the sweep of modernity, juristic discourse on pragmatic eclecticism in modern Egypt. This is where he talks about Ali Pasha and the role he played, what he tried to do, codification and the Arab Spring, and then conclusion. So it's really interesting. On page 4, like I said, he defines what he is labeling as the term as pragmatic eclecticism. So he says, if you have a look here as well, he says pragmatic eclecticism is more or less the author's word, or the author's, you could say, terminology to describe all forms of Tatabbu, al-Rukhas and Talfiq. So he says, he mentions here, it was also owing to the negative connotations of Tatabbu al-Rukhas that jurists, especially its proponents, sometimes avoided using the term, and instead described a process in which the jurist's choice of juristic opinion is motivated by the legal result as opposed to evidentiary grounds. To avoid this terminological indeterminacy in the primary sources, which is compounded by the occasional absence of any terms in the Arabic sources, as well as the use of different terms diachronically to refer to the same phenomenon, as is the case with Tatabbu, al-Rukhas and Takhayyur, I use the term pragmatic eclecticism to refer to Tatabbu, al-Rukhas and Talfiq in a general sense. When a distinction between Tatabbu, al-Rukhas and Talfiq is required, I maintain the Arabic terms or use the phrase complex pragmatic eclecticism to refer specifically to Talfiq, and simple pragmatic eclecticism to refer to Tatabbu, al-Rukhas. Tatabbu, al-Rukhas obviously being the idea that you take from the madhahib based upon, you take the rukhsah in each madhab based upon whichever one you want to take, so the easiest one. So here I thought there was a balanced comment firstly on page 13, and again the book is really good. However, there are some things that I just want to kind of maybe speak about, which I think do need a bit of attention to. So he says here, and he explains on page 13 here, that Ijtihad essentially allows flexibility, whilst Taqlid maintains stability. And that's a really interesting point. Thanks to the work of contemporary scholars who challenge the rigidity narrative, there is hardly a historian of Islamic law today who would disagree with the proposition that Islamic law, like any other legal system, has experienced throughout its long history instances of change motivated by the realia of law on the ground. Rather than argue that Islamic law stagnated under the regime of Taqlid, or claim that jurists had an unlimited prerogative to depart from school doctrine, doctrines, a more plausible account should not overlook the essential relationship between the two legal ideas of stability and flexibility, understood through the Ijtihad-Taqlid continuum. A mature legal system develops mechanisms to manage these two legal principles to minimize ruptures while ensuring that laws deemed unacceptable to jurists can be modified, with the caveat that change in the exception is the exception and that the rule is continuity. Legal systems, whether in the common law or civil law traditions, are characterized by what Alan Watson calls legal inertia or inaction, terms that refer to an aversion to legal innovation and the need to maintain the stability of legal rules. So ijtihad will create some flexibility, but taqlid allows stability, and both are incredibly important. Page 21 is where the author more or less tells us what he's done in this book, and it's really, really interesting, by the way. He says here, in chapter 4, I show through the study of 3 courts in Cairo and Bulaq that the change of school for pragmatic purposes was practiced in the Ottoman period in ways that correspond to both Tatabbu, al-Rukhas and Talfiq. This practice helped jurists establish a more flexible taqlid system by drawing on the diversity of legal opinions within the 4 schools. In chapter 5, I discuss, and he continues, and he explains in the book, by the way, that the Mamluk Egypt under the Mamluks is where we really get started in this idea of Talfiq, or you could say Tatabbu al-Rukhas, according to the author, by the way. So he says, obviously, Sultan Baybars, when he created the 4 chief qadis, this really made a huge difference, and this allowed the different qadis to now utilize the other madhahib to help solve problems for the society. Essentially, it allowed them to become pragmatic. So he explains that on page 41 to 44, he explains how, and he, by the way, goes through a really, really interesting discussion here on the Mamluks themselves, the history of the Mamluks, really interesting part here. Then the Ottoman Hanafization versus Mamluk pragmatic eclecticism. So the Mamluks really, they preferred this idea that each madhab sticks to their own approach, but then we're allowed to choose between the different madhahib. And so he mentions this here, the expansion of the Mamluk bureaucracy, as well as the commercial need for a reliable legal system capable of providing merchants with a flexible contract law that could facilitate the management of the wealth that they have accumulated, created the institutional necessity for institutionalizing forum selection. Forum selection is more or less like taqlid mutlaq, or what we might refer to as even more, might lead to talfiq as well, in the regime of taqlid. This process started with Sultan Baybars requiring the Shafi chief judge to choose deputies from amongst the other 3 schools, presumably to permit transactions and contracts not deemed legitimate under the Shafi'i school. So it allowed them to kind of select from the madhahib different opinions that would help to solve problems in society. And then he explains how when the Ottomans came into power in Egypt, for a little while, like Selim I, for example, he tried to really impose Hanafism in the first decade after conquering. So he says here, and he explains the Ottoman attempt at Hanafization. So he explains firstly about Selim and what happened. Then he says the Ottoman attempts at Hanafization riled not only local jurists but also the laity, who faced occasional disruptions in their ability to navigate the legal system. In his Qudat Misr, Ahmad ibn Muhammad al-Damiri described the Ottoman judge Muhammad Shah bin Hazm, who arrived in Egypt less than 50 years after the Ottoman conquest, as rigid and unfamiliar with Egyptians who were accustomed to leniency. Tubi'u ala al-lin. So this is quite interesting that Selim did try for the first decade, Selim I, after conquering Egypt, but he gave up. And Egypt from those days until today remains a place wherein it's very, very flexible. The system is very, very, you'll get everything in Egypt, where you could get literally followers of the Shafi'i madhab, Hanbali madhab, Maliki madhab, even the Shafi'i madhab, everything, and even those who don't have any madhab at all, everything will be found there. And this is where the author now starts to discuss the permissibility of Tatabbu al-Rukhas, which is really interesting. He tries to go to lengths to explain, and this is, again, this is something that really needs to be looked at. The author argues that later on, Tatabbu al-Rukhas was accepted and Talfiq became the thing that they would not accept. And I find that really, really interesting, and I find it something that I don't entirely agree with. Having checked up some of the quotes that the authors used, I don't think they prove his point very well. I think Tatabbu was always considered a problematic idea, but Allah knows best. Only the only few handful of scholars that allowed it, like Ibn Humam and Ibn Izzuddin ibn Abd Salam, he does discuss them as Samhudi, but then some comments I don't know. Like for example, on page 119, he says that Ash-Shurumbulali, He says, Ash-Shurumbulali claimed that early authority. He says here, although Ash-Shurumbulali was one of the supporters of Tatabbu al-Rukhas, he was staunchly opposed to Talfiq. Again, Samhudi, that Ash-Shurumbulali is summarizing quite a bit from a Samhudi, so that needs to be mentioned, and that kind of needs to be understood as well. So that could be causing it, and also it really needs to be checked how he's allowing Tatabbu al-Rukhas. From my readings of Shurumbulali, he's not saying it to the level of just Tatabbu. There's a difference, and this is why I'm trying to say that I'm not 100% sure if the author has adequately ascertained whether all the examples of Tatabbu al-Rukhas that he's using in this book are actually Tatabbu al-Rukhas or Akhdhu al-Rukhsa. One is chasing after leniency in Sharia, and one is to take a leniency. It seems like some of the examples in the court practices as well, Allah knows best, might be taking leniency instead of chasing after leniency, and there seems to be a difference definitely between the two, as Ibn Hajar al-Haytami and others have also said as well. So he gathered these court records, by the way, and he goes through here all the court records as well. He gathered them these court records. He gathered them in 2009 to 2010, and he discusses how he gathered them, etc., from 3 different courts in Bulaq and Cairo. So quite interesting point and interesting discussion here, definitely. But what I found really beneficial, by the way, is his discussions on things like, for example, how the madhahib developed. So on page 105 all the way up until 111, so more or less from here onwards, Talfiq in Juristic Discourse, until 111, he discusses how the first discussions on Talfiq actually begin around about 400 to 500 Hijri, which tells us that the madhahib actually developed around about that period. So it's actually only in the 5th century or 6th century where we have the first earliest discussions on Talfiq. So the rise of Talfiq in Juristic Discourse, and that tells us a lot about the development of madhahib. If they've started to discuss Talfiq, that tells us the madhahib are developing into proper legal systems now. He discusses other things as well in the book. By the way, I've mentioned a lot of this in my notes. You'll find this very interesting. For example, he discusses how the impact of even scholars like Qadri Pasha and Majallah. He discusses Majallah and how it was like a kind of response to the modernity and the Tanzimat that were taking place. He has a really nice summary, by the way, of the Tanzimat and what it involved and what it was all about. On page 205 he goes through the Tanzimat themselves, legal transformations in 19th century Egypt. He discusses in quite a bit of detail. He actually explains how Ali Pasha actually tried to Mehmet Ali Pasha, he actually tried to force Hanafism again back into Egypt, just like Selim I had done, but it never really worked. And he also discussed on page 206 Qadri Pasha, like I said, he's got a full book, Ahwal al-Shakhsiyya, Al-Ahwal al-Shakhsiyya, and he's quite interesting because he seems to have tried to do in Egypt what the Ottomans did in Istanbul, where they tried to come up with the Majallah. So he tried to write a full kind of code, if that makes sense, family code, etc. as well for Egypt. So he says there was an attempt in Egypt by Muhammad Qadri Pasha to introduce an Egyptian Islamic legal code similar to the Ottoman Majallah in the 19th century, but it never attained official status. So again, really interesting discussion. It's all primarily about Egypt, but he goes into all the discussions of Izzuddin ibn Abd al-Salam, Ash-Sha'rani's discussions, everything. Really well researched book. Again, maybe a few flaws here and there in terms of his arguments. I don't know if they fully hold up. They need to be checked up, some of the comments. So that I'll leave that for the readers to do, but I think you'll really enjoy this book. I thought it was just a fantastic read. And like I said, if you want to access my notes, you can go onto the Islamic Knowledge Telegram channel. Just go onto Telegram and type in @IK Courses. You will see the Telegram channel there. I hope you enjoyed this video. I hope you do get a hold of this book. Like I said, it's about 200 or so, close to 300 pages of solid reading. Not really 300 actually. If you have a look, it stops at page 237. So 237 pages of solid reading. Really fantastic book. I highly recommend it. It also shows how the madhahib is a changing phenomenon. It moves with the times and it develops over time. It's not stagnant at all. So I hope you enjoyed this video. Please do join me on the next one. Jazakumullah khair. Wassalamu alaikum wa rahmatullahi wa barakatuh.